I think part of the problem is this distinction that seems to be made when it comes to intellectual property between hard IP, which is only the stuff you can patent, and I'm using air quotes here mentally, soft IP, which consists of trademarks and the brands that they encompass, copyrights, trade secrets. And I think the biggest misconception is that an intellectual property asset is only valuable to the enterprise if it's a hard IP asset. I think they underestimate and also underdefine the scope of what IP can mean.
Welcome to the Intangible Brand, where we explore the connection between employee experience and client experience and the hidden forces that make brands stick. I'm Jerry Gennaria, and I'm joined today by my co-host, Carl Winstead. And today, our guest is Sharon Toerek. She's an intellectual property and marketing law attorney, and she's the founder and principal of Legal and Creative. She helps creative professionals and agencies protect, enforce, and monetize their intellectual capital. And she has deep experience in trademark and brand protection, copyright, agency relationships, and marketing compliance. Sharon writes and speaks frequently on legal issues that intersect with creative work and brand strategy. And she served in leadership roles, including being past president of the American Advertising Federation in Cleveland and a member of the 4A's Legal Consultants panel. She's also the creator and host of the Innovative Agency podcast, where she explores trends and ideas shaping the future of agency leadership and innovation. I don't know how she found time to be with us, but Sharon, thank you for being here.
Thank you, gentlemen. I'm excited to have the conversation today. I appreciate being here.
Great, Sharon. Yeah, thanks so much for joining us. Jerry, first a quick little deal. We're in a little bit different situation where today we're actually broadcasting from the Klein's new office in Austin, so the background's a little different. But we're so glad to have you here, Sharon. I wanted to start with, can you tell us a little bit about yourself and really about your journey, and maybe what led you to focus on intellectual property and then to found Legal and Creative?
Well, so I think my journey starts with me being kind of an IP nerd originally, and trademarks were the first exposure I really had in my legal career to intellectual property. I eventually came to discover that there's lots of different kinds of IP, but I my first job actually out of undergraduate school was in a law firm supporting its trademark law practice, and I just loved the front row seat to creativity, and it was my first taste of understanding marketing a little bit because our clients were all involved in marketing to some degree or another. And so that's just a thread that is carried through my entire career, including to this day. So expanded the practice, and once I had my own entrepreneurial seizure and started my first law firm, uh, and started working more and more with marketers generally, and then agencies more specifically over the years, until I founded this firm about a dozen years ago to serve independent marketing services agencies. And, the other part of the thread that is sort of stitched through the whole experience is that I love having a front row seat to the creativity of our clients, and I love seeing the impact they have um, on our economy, on our culture, and on their clients' business results. And a big part of that is due to the creation of the IP that they do on a daily basis, and brand protection is a key component of doing that in a way that makes it lucrative and monetizable. And so, yeah, that's kinda how we got from there to here, and, I am a professed trademark nerd, so I love talking about brands and brand protection and really all forms of IP, but I'm not gonna lie, I'm kinda thrilled that we're gonna talk brand today.
That's awesome. And
Great, thank you.
love the shout out to Michael Gerber with the entrepreneurial seizure. One of my favorite phrases of all time. And if you haven't
Yeah,
read the book, by all, definitely recommend his E-Myth book.
yeah.
So
He's the
I am
OG.
also yeah, I am also a trademark nerd. In fact, you and I have talked about collaborating on a little guide for agencies about trademark. So I'm wondering if maybe as we get started, could you tell us a little bit about how do you define the role of trademark and intellectual property within brand strategy? What should a brand leader be thinking about or understand first about intellectual property?
I like to think of it, we use a triangle metaphor here at the firm, and that's kind of the rubric through which we look at all intellectual property. And every professional services company, and I can't think of a single products focused brand that doesn't have a massive inventory of IP. They don't exploit all of it. Some of it is internal only, some of it is market facing, but and the 3 points of the triangle are really brand, which is a big part of what we're gonna talk about today, and the typical legal strategies and frameworks for protecting brand are trademark strategies. The second point of the triangle is content, whether that is software or words and pictures or, any combination thereof. Typically, it's protectable via copyright protection, sometimes trade secret protection. And then the third point of the triangle is your transactions. And these are the terms and conditions, the contractual relationships that protect intellectual property and make sure that the ownership and the control of it is in the right place and reflects the intentions of everybody involved in the creator process because as we all know, IP isn't always created internally. Sometimes we pay others to create it for us and we will own it. Sometimes we create it internally. Sometimes we use freelance help and employed help to sort of team up on it. And the transactions need to reflect that. And when you go out to market with it, you're not always doing it, and you're very infrequently doing it as a work for hire. So you need contractual frameworks in place for that part of it. So I want them to understand. I want anybody listening to understand that it's a flywheel between the 3 points of the triangle, and every point of the triangle makes the other 2 stronger. And trademarks are a huge component of that because they're the legal basis for owning the monopoly on your brand, which is important if you're gonna invest money and time and other bandwidth into it.
Yeah.
That's good. Yeah. Sharon, I think business leaders, a lot of times you mentioned sort of the triangle. I think a lot of times business leaders are very aware of things like spreadsheets and AR and a lot of other sort of market things. But I think there's probably a misconception with business leaders about trademarks and legal brand protection. And I know a lot of firms, especially like in the AE industry, um, they're smaller and they really aren't necessarily used to kind of getting attorneys involved early on in things. So I'm just wondering, like from a business leader point of view, what are we missing, and what's our misconception as business leaders about trademarks?
I think part of the problem is, and I'll blame the legal profession for part of this, is this distinction that seems to be made when it comes to intellectual property between hard IP, which is only the stuff you can patent and own a patent on, and I'm using air quotes here mentally, soft IP, which
Mm,
consists of trademarks and the brands that they encompass, copyrights, trade secrets, and I think the biggest misconception is that, an intellectual property asset is only valuable to the enterprise if it's a hard IP asset. And I would just say in response to that point of view that Coca-Cola is a multi-billion-dollar global business consisting of primarily soft IP. Its power is in its brand, its secret trade secret recipes, and the like. And so I think they underestimate and also underdefine the scope of what IP can mean, in terms of dollars and cents value to the company. And then I think I think it's, the other specific to trademarks and brand protection, I think a big misconception is that brand leaders don't really understand how to define, um, from a legal point of view, how do you really own your position in the brand? It's a combination of understanding that it's a category specific thing. So being inclusive, in some cases and exclusive in other cases in terms of clearing it before you put it out into the world. What we least like to see is going to market without, um, verification and due diligence around a new brand or, a new iteration of a brand. Those, are really expensive and time-consuming decisions, and so I would say those are some of the big misconceptions that I think business leaders have around intellectual property.
Okay. Yeah. Thanks.
So, digging in a little bit more on trademark and why it's important, because I think just setting the stage, right? A lot of our listeners are in professional services, might be architecture or engineering, or even financial services or things. And a lot of times those firms start small. They start very local and regional, and they're often named for the founders of the firm or something of that nature. And it's the kind of business that perhaps started 20, 30, 40 years ago, didn't even go through the trouble of obtaining a trademark. Um,
Mhm.
as the firm evolves, maybe that, becomes more of an issue for them. But I think maybe part of the misconception is, what is the, business asset that a trademark functions as? We maybe understand it as a sort of legal shield or protection. You can't use this name in this way in this place because I have a trademark on it. But that feels very, I think for some people, maybe like it's putting on a seatbelt or something. It's a defensive maneuver when trademark, I think, has a greater function as a business asset.
Right. I agree. I think the best way I could put it would be to say to those business leaders, think of it like putting your stake in the ground for your brand. That is
Mm,
really, I think at a very high level, the value of brand brand ownership and the trademark underpinnings for brand ownership. Um, Owning the legal rights to use your brand is, first of all, it's a source signifier. It tells the world that the provider of whatever it is you sell out in the world is you, and that there's a certain expectation they can have as to the quality, the authenticity, the reliability of what they're buying or investing in based upon who's offering that product or service. Trademarks help you do that. They also help you establish your legal monopoly, if you will, over the ability to use a term or a logo or a combination of those things, um, to identify specific categories of products or services so that somebody who looks for your stuff is not going to be confused about whether it's you versus perhaps a competitor who's trying to rip off your brand. So it gives you legal leverage, yes, and we've kind of talked about that. And but as far as a business asset, it is your stake in the ground to signify the source and the quality and the authenticity of whatever you're offering to the market.
mm,
So it is a hallmark, um, of your ability to be exclusive and to monetize, the brand overall.
yeah, that's good.
Well, it's interesting. Yeah, you sort of gave a sort of a picture of the steak idea, and especially in the tea industry, we love things that are very tangible. I think that just that picture of the stake in the ground is a great way to sort of see that.
Yeah. I would
Wondering,
say
yeah.
I'm sorry, go ahead.
No, go ahead. Yeah.
Well, the other thing I was gonna point out for business leaders who might be listening to this is that it's a pretty good barometer of the growth and the financial success of your company to have a larger portfolio of trademarks and brands versus a smaller one. And that's not a vote for, over diversification or trying to be too many things to too many people. It is that in general, it's a generalization. The other reason you ought to care about trademarks as a business asset is not only putting your stake in the ground, but the larger your portfolio of brands and trademarks, the more revenue centers you are more likely to have as a company, the larger your market is likely to be, and that's the people or companies who buy whatever it is you're selling. And probably the broader the geographic range is of your business and the products and services that you sell. So, not only is it a stake in the ground, but it is a barometer for the growth and success of the business, which increases the perceived and actual value of the business over time.
So let's follow that for just a minute because you're now talking about trademark being part of a business strategy. You talked about growth and diversification. So I'm wondering if there are maybe some examples that you've got of how trademark strategy can actually boost or protect a firm's value, say when you're entering new markets or you're thinking about diversification, new service lines.
Mhm. Right. I think one of the best examples of this is companies who build franchise businesses based on the strength of brand, right?
Mm,
A franchise is a combination of a set of business operating procedures that have been proven to work over time, sort of a how to manual for somebody who's dipping their toe into entrepreneurship. But
right.
mostly what it is uh, a strong trademark or trademarks, family of trademarks that signal over a broad territory the quality of the thing that the franchise organization is known for selling. And
Mm,
so somebody buying a franchise is buying the brand. They're not just buying the how to do it manual because, they could be figuring that out although more slowly on their own and not
mm,
paying franchise fees and royalties. It is the power of the brand. So that's one, great example of the power of brand. The second I would say is companies in particular industries like beauty, fashion, who have taken a brand and made a career out of licensing it or created a
mhm.
business model, I should say, out of licensing it in other product and service categories because the brand is so ubiquitous and powerful in one category that it can transcend over into others. And so it's an entirely different revenue center for them to license the brand um, for other categories of products and services over time. So I think those are two very different um, models of how you can take brand and the trademark support for brands and actually turn them into business models that create revenue.
Yeah. Okay.
And I
Interesting.
and I wonder with with service firms if it isn't also about the services that you offer and whether or not, there is intellectual property behind that, um, that's a separate conversation about trademarking the intellectual property of a process, but naming that process and trademarking the name of that process, could be another way that an organization expands the value of their brand portfolio and ultimately creates more, um cachet for the service that they offer. I mean, because I think we're
Right.
always struggling for differentiation. So when you're able to have a legally protected name for your process, then it even if it's essentially the same thing that somebody else does, it's your version of that.
Yeah.
Yeah, I agree with that, Jerry. And I also think that professional services firms um, create a ton of intellectual property on the content point of the
Mm,
triangle. And um, we saw a little more of this during the pandemic. I haven't seen professional services firms sort of take to this as much once the economy picked up again after the pandemic. But they have taken their knowledge base, if you will, to create, more productized versions of their knowledge, like, courses, online
Mhm.
learning academies, discovery products, and each of those offerings can have its own brand, and they can
Right.
either be a riff on the main brand of the professional service company itself, or, there's lots of options. Jerry, you're an expert in this, um, to create a family of brands or related brands that identify the more productized versions of the knowledge base that a service provider has versus the actual fee for service work that they do on a custom basis day to day. So, um, yeah, I was getting pretty good traction, particularly with we work with marketing agencies as our primary client base, and it's hard to get them interested
Mhm.
in doing this because it diverts some focus away from their customized, fee for client work. But there's lots of additional revenue streams to be had there, and trademarks and the brands that the trademarks support for those additional offerings is a huge part of that strategy.
Yeah. Oh,
Jerry, we talked about that a little bit, just you and I, about like in the work that we do in multifamily. Is there something unique about the process in which
mhm.
you design a multifamily project versus the process in which you design an affordable housing project? Is there something about your process um, that makes it unique, makes a differentiator, and yeah, something that you could even then offer to train other people? This is the process. So I think that's a very interesting way to think about it as we, kind of continue to evolve down the road.
Yeah,
Right.
and I think it's interesting because we're really this is all intellectual property, but we're really talking about 2 areas of intellectual property. We're talking about, a process, which is really gonna be either a patent or potentially a copyright. I guess a patent would be
Or
the
trade
stronger,
secret.
or a trade secret, yep, and that's gonna require, I think, some degree of uniqueness. Maybe not on the I'm not sure. I don't know a lot about trade secret, Sharon, so you might wanna illuminate that for us a little bit, but I know on a
Sure.
process patent, it can't just be, that you can't do it the same way everybody else does and then go and patent it. That just that doesn't work.
Yeah.
That's true. No,
But
I don't we don't practice patent law, but I can tell you I know enough to be dangerous, and I know that this is true, and that is that it has to be novel, right, in order to be
yes,
patentable.
right.
Useful and novel, and there are some other requirements as well. But, um, it doesn't if it's original and tangible and can be expressed in a tangible format, it can be copyrightable.
Mhm,
And if it is an asset that, whether it's a system, a process, a methodology, whatever it might be, of any body of work that can provide some um, advantage to the business
mhm,
vis-a-vis competitors to the business, and if it's confidential or only disclosed to people who are under a contractual obligation not to share it with anybody else, then
mm,
it can be protected as a trade secret. And
mm,
so you know, going back to the franchise example, just because it's so rich with, metaphors for how this works, the process and procedure manual that a franchisee might be required to follow, it's not only contractual that they do that, but it's also that stuff is a trade secret and they're not permitted to disclose that, to somebody
mhm,
down the street who wants to start, for example, a competing business. So there's power in all different forms of potential IP protection. And the flywheel really works when you stitch them all together, when you have a body of IP that is represented by the brand, so it can be identifiable. Um, Whatever protection theory applies to the content,
mhm,
which could be a knowledge base of a professional service company, it could be a process and procedure system for a franchisor, whatever it might be. And then, the contracts and obligations and terms that impact all those relationships, which is the third point of the triangle. And so they work as a flywheel, and one starts to beget the other, which starts to beget the other. And before you know it, you have a really valuable portfolio of IP that can, in some cases, be broken off from, if the owner of the company desires, the main business of the firm. You see a lot of founders of professional service companies, for example, deciding, you know what, I'm ready to move on from fee for service work. So I want to sell my consultancy, my agency, my accounting firm, whatever it is. But there's this body of knowledge that I created as I was building my business, and I wanna be able to go out into the world and teach that to other people, or I
Mm,
wanna be able to create a book out of it or create a course out of it and monetize that stuff. So you can peel it off from the business that it supports, or create a deal between the 2, to go off and do other things. So the doors that IP and taking a systemic approach to protecting the IP opens, for businesses at all, sizes and scales, is tremendous. But I think the impact is even more meaningful in smaller companies because the options are just plentiful.
yeah. Are there places where firms are missing, legal exposure that they have in their brand and IP ecosystem?
I think one um, key area of potential exposure that most brands probably don't pay attention enough to is the potential advertising exposure, that they may have, and what I mean by that is making sure that the representation of their brand by influencers, by their
Mm,
affiliates,
mhm,
and social media channels, aligns with their brand values, their brand standard guides. So, what I would call the advertising exposure. And it isn't typically that these brands don't understand that that could be a risk. It's that they don't have any programs in place to monitor. Nobody's taking a look out at the social channels. Nobody's, you know, putting their binoculars out on the horizon to see what other uses might be out there. AI is making this even more complicated because AI is going to make it possible for unauthorized duplication of brands and other IP out into the world, and it's kind of whack-a-mole.
mhm.
But not looking and not having a system for looking, I think, is one major risk, our area of miss. And then I would say, specific to trademarks and brands, um, brands underestimate the amount of risk they're taking on by not taking prompt action if they see somebody misusing their brand out in the market,
Mm.
or if they see somebody um, conflicting with their brand in some way, shape, or form that could be infringement. You sit on those situations and you don't take action on them. They get viral fast, and also you could be compromising or sacrificing some of your legal options by doing that. So those are two that come to mind,
Yeah,
kind of off the top of my head.
that's a good point. We've seen cases where, there might be 2 businesses in a geographic area that share a similar name, one that probably the second firm, would not be able to trademark because the primary firm has the trademark on it, but they've coexisted for so long that
Hmm.
it would be very difficult for the primary trademark holder to ever really do anything in court about it. I mean, again, everything is up to whoever is
Mhm.
behind the bench when you go to court, but,
Right.
just in terms of the underlying, the underlying desire of trademark law to be about consumer protection, right? That's the fundamental underlying thing about trademarks is it's about, reducing confusion in the marketplace, and
Yeah.
so
Right.
if you let it go to that point, then it becomes hard to argue that there's confusion in the marketplace.
Right. And I mean, we've seen heartbreaking episodes, or incidents, at my firm, of people who were first adopters of their brand and who didn't seek trademark registration so that they could
Mhm.
start acquiring the rights associated with registration, and a later comer ends up registering their trademark in
Right.
a similar category because the trademark office isn't going to do a scan of the marketplace to see what unregistered uses are out there. And so you're in the position of being the senior user, if you will, and you have a junior adopter who owns the trademark registration. And so you have to take some sort of legal action if you want to write that. We've also had situations where brand holders have inadvertently let their federal trademark registrations expire and
Mhm.
had bad actors come in, and swoop in, and register them for a competing, product or service. And so there are definite financial and legal risks to having lack of due diligence, and so you need a plan. It's one thing to clear your intellectual property. It's another to register it to get those statutory protections that you might be entitled to. It's a third thing to be constantly sweeping the marketplace to make sure that if something's happening, you're taking action as promptly as you reasonably can.
Right.
Yeah.
Vigilance in protecting the brand. Yeah.
Right.
And that's
100%.
it's a good point. There's trademark law in the US is such a fascinating thing. I think maybe more than almost any other major developed country. I think it feels like Europe has a much more structured approach to registering and enforcing trademark. In the US, like so many other things, is sort of a patchwork of statutory and common law and all these kinds of different kinds of protections. But it creates all sorts of weird things. My favorite is Burger King, which obviously has a trademark on Burger King everywhere except for this one small area. I think it's in Indiana, where
Uh,
there's a senior business that I don't think they didn't have the trademark on Burger King, but they were in business before, and so they ended up creating a carve-out, a geographic carve-out for this business because they were already using Burger King. So you can go to a
yeah.
Burger King, I think it's in Indiana, that is not what you think is Burger King as a result.
Mm. Yeah.
I was not aware of the Burger King example, but yeah. So I the main difference between the US approach and, let's say, the EU's approach, for example, because this is the best probably illustration of the conflict between the 2, is in being a first to use versus a first to register.
Register. Mhm.
Um sort of, mechanism, and we've always been a first to use, which means that in the US, you can have common law rights that predate anybody else's registration, and therefore, you have these weird carve-out situations. This wouldn't happen in the EU, where if you got to the trademark office registration system first and registered it first, then your the earlier users are in jeopardy of maybe having their rights taken away from them. So, but at least it's easier to predict what an outcome is going to be. You're
Right.
either first to register or you're not. In the United States, it's a little bit more difficult to figure out where you're going to end up because of the conflict between the common law and the statutory law that protects trademarks.
Right. I
Interesting.
mean, I think the good news in the US is that that means that a lot of small businesses that never thought about registering a trademark, at least in their geographic area, have some degree of protection. In the same way that a photographer who takes a photo immediately has copyright of that photo without registering it. But if you register it, you have the opportunity for additional damages in the event that somebody misuses it. But at
Right.
least you have that protection that accrues to you naturally.
Right.
Yeah, it's fascinating.
Yeah, it's as fascinating in the exceptions as it is in the rules,
Right.
which is probably another reason why I like IP law so much.
Sharon, you mentioned just a minute ago, you sort of cracked the door to the discussion about evolution. Brands over time evolve into their own ecosystems. And you mentioned that, sort of franchising, you've got names, services, social media, all of that. It's very clear that we are living in a time of transition, evolution, and it's happening very quickly. I don't think we have all the rules in place for how fast things are happening, but I'm wondering, as you look ahead, say the next 5 years, how do you see sort of our trademark strategy evolving? with just all that's happening in evolution of just our society and just in general?
I think, first of all, that, we're gonna see it take a lot longer to achieve legal protections,
Mhm.
of trademarks. The sheer volume of applications at the US Patent and Trademark Office, has exponentially increased the amount of time it's gonna take us to get a result, in terms of whether a mark actually will be registered or won't be registered. So I don't expect that any significant relief there for a while. Although, if you ask the trademark office, they've got all kinds of plans to do better and faster. And um, so I think that's one risk. I think we will continue to see attempted brand expansion, and this is where a brand owner will seek either by licensing deals or by product category expansion to broaden the scope of and therefore hopefully the value of their brand portfolio by applying it to different products and services. Um, and I also think that the rise of use of AI, generative AI, to create marketing and advertising content that incorporates brands means that we're going to see more inauthentic and fake use and unauthorized and in some cases damaging uses of counterfeit brands and duplicated brands
Yeah.
in ways and in applications that the brand holder doesn't actually approve of. So I think those are three elements of the ecosystem that we're keeping our eye on. um, on the positive side of things, AI can help us be a little bit faster and more efficient in doing the due diligence that we need to do to clear a brand that is new
Mhm.
that somebody wants to adopt. But it doesn't take away the need to go through the same due diligence process. It might just make it a
Sure.
little bit faster and more efficient.
Sure. Makes sense.
Are there other concerns related to AI or generative tools, either with trademark or content as the another point on your triangle that we need to be thinking about as marketers?
Well, I think as marketers, the risk of infringement
Mm,
incidents will only increase because the AI purveyors are they're very clearly at scale dumping original IP into their trading systems, and there's no way to control what comes out on the other side. And
mhm,
so the likelihood of incidents of infringement is going to be higher. Um, the dilution or potential dilution of brands because of unauthorized use of the brand or poor quality replicas of the brand um, is something we're going to have to watch out for. Um, I think what AI is good at is being a thought stimulator, a thought
mhm,
partner, perhaps a concept generating assistant, but the actual replacement of sort of the human in a loop in terms of determining does that brand really land well with the values and the offerings of the company that wants to use it to identify something it's going to take to market. Those I think still remain human functions, and those are
yeah,
judgments that humans still have to make. So I mean the tools will make some aspects of IP protection faster and more efficient, but they're going to create, in my view, a higher incidence of risk for infringements or just sloppy representations without authorization of the brand holder of brands out in the marketplace. Crummy looking advertising where the brand
mhm,
doesn't look the way that the company intends it to look, or misuse of it. I mean, I'm sure you've both seen this, you travel to some resort town and they've got a fake Starbucks looking logo, on a t-shirt advertise. So we've just created a million tons of digital real estate upon which things like this can continue to happen. And so we just have to be vigilant.
Right.
Yeah. Yeah. We talk a lot kind of on this podcast, especially about the intersection of the employee experience and the client experience. And I'm wondering kind of your thoughts on kind of where trademark strategy might fit into the role of with client experience or employee experience.
I think that the best and most protective systems when it comes to IP are team effort.
Hmm.
I think they're a team effort between the marketers in an organization or externally who are advising an organization, um, the legal advisors, either internal or external, the IT people, who are in charge of making sure that the technical systems support whatever brand protection goals that they are intended to support. I think it needs to be a multidisciplinary approach.
Hmm.
And I think the earlier you bring in the cross collaboration to the process, the tighter the IP protection is likely to be. Um, and, for those of you who might be enterprises or serve enterprise clients, um, my observation and occasionally working, with them because our clients are serving them is that they're not talking to each other. You have to sometimes force them into a room together or force them on a call together to be collaborative, and it costs more money and time than it needs to. So that is I think my number one takeaway for everybody is that a multidisciplinary and team focused approach, and one that starts as early in the process as is possible, are indicators of a higher likelihood of success.
Yeah. So if you were able to have a room full of 20 or so professional service business leaders and you could tell them one or two things point blank, what would you tell them? What would you say to those group of 20 leaders?
Right. So, first of all, I would have a trademark clearance protocol in place. What is your process? Either who are your people, or what are the steps that you follow, at least to do pre-clearance in the trademark, landscape. Have a process and a protocol, and socialize that protocol and process amongst the team members who need to know about it. That way you are not having those oh my goodness moments when you are in the midst of a very exciting creative process that gets too far down the line before anybody has thought about doing the due diligence. So, having a process in place and a protocol in place makes it less likely that you're going to have a problem to solve later. That would be my first tip. Um, my second tip is that once you put a brand out into the world, your legal enforcement is just starting. Really, it's not ending, and so have a regular process thought through about how are you going to audit the way your brand shows up in the world. Um, who is going to again put those binoculars on and look at social channels on a regular basis? Who's going to be monitoring the Google alerts or whatever the equivalent of those end up being, in the future with AI being present? Um, but who's going to monitor the integrity of how the brand shows up in the world? Have a protocol for that as well. So those would be, I think, my top 2 suggestions. Have a clearance protocol in place and have a brand monitoring protocol in place, including a general idea about who's gonna be responsible for what parts of those things.
Yeah, that's great.
Good advice.
Are there tools specifically for the brand monitoring from a trademark protection perspective that you recommend? 'Cause I wonder if our listeners are know where to start.
Yeah, that's a great question, Jerry. I mean, there are trademark monitoring services that you can employ, LexisNexis, Thomson Reuters. A lot of enterprises just have subscriptions to these and put them on Trademark Watch so that they get regular reports of where their brands show up in the world, and they can check the results of those presses. Um, I would say just setting up Google Alerts is it's free to do.
Yeah.
It's, you can decide how frequently you want to check into them when you get them, and you can be judicious about who's gonna be in charge of monitoring them, but, that is just low-hanging fruit in terms of, ways to figure out if there are brand mentions. And then the social listening, um, tools that are out there, and I'm sorry, I don't know which ones are the most popular right now, but any tool you would use to sort of find out whether, some newsworthy event is happening,
Mm.
can
Mhm.
be used and manipulated to, um, trigger an alert to you when a brand is being mentioned or a brand close to your brand is being mentioned so that you can take action.
Yeah, that's good. Good advice. Um, so we talked a little bit a second ago about what business leaders should be thinking about. I want to close out by asking you what marketers and brand stewards within an organization, not necessarily leadership, should take away from our conversation today. What should their focus be on?
I would like people to walk away with an understanding that for just about every business out there, IP is either your most significant or one of your most significant assets, and that you are very likely under investing in protecting it or under leveraging it as an economic money producing asset for your company. So take the time to examine your landscape within the company and look for those gems that are swept into the corners because you're leaving money on the floor. And if everybody here could just take a little bit of time to be thinking through what are some assets that we might be under leveraging or not leveraging at all,
Hmm.
and or what are some assets that we know are important to the business, but we have not invested the time or treasure in protecting them or clearing them. That's the takeaway I'd love everybody to have from today's conversation. IP is money. For just about every business, it's your most significant asset.
That's awesome. Yeah.
Yeah. Sharon, thank you so much.
My pleasure.
Thanks for sharing these insights on these connections between intellectual property, trademarks, and brand strategy as part of a company that's starting to grow a little bit. This has been a very good conversation for me, and I may have some new job descriptions that I need to fill in now. But those are great things to think about. I would ask one more thing. We always ask our guests one final question, and it's not a very difficult one, but I am curious. Is there a book or there a podcast or something that you would recommend that our audience pay attention to?
So I love The Diary of a CEO,
Mm.
with Stephen Bartlett. He is a young British man who is brilliant and asks the smartest questions, and he has experts on his show in business, technology, health, culture, um, you know, politics, all of it, and asks the most fascinating questions. And I've never seen a podcast host like prepare more deeply, and the episodes are fun to watch as well, so that would be my number one. And if you care about business, then only watch the business-focused episodes. If you care about health, there's something for everybody, but yeah, Diary of a CEO, Stephen Bartlett is my number
Okay,
one pick.
Awesome. We're going
great.
to put that in the show notes for everyone.
Awesome.
Sharon, where can our listeners or our viewers find you online or learn more about you and Legal and Creative?
Well, first of all, thanks for the chat today. I really enjoyed our conversation, and you all ask wonderful questions. You can find me on LinkedIn at Sharon Toerek, Toerek. The law firm is Toerek Law. We do business in our client industry as legal and creative. So you can find us at legalandcreative.com. And yeah, feel free to email me at Sharon at. I love getting questions, especially about IP from people. So be happy to chat offline with anybody who needs some help.
Well, I'll certainly put a plug in. We've worked with you. A number of our colleagues and other agencies have worked with you. And if you're looking for someone to advise you on intellectual property matters, particularly around trademark, I would definitely recommend talking to Sharon. And in fact, I'll put another plug in. Toki does another show called Toki Office Hours that we do once a month. And I think it's going to be in April, but at some point in the near future, Sharon's going to join us. We're going to get a little bit more into the nuts and bolts of trademark law and the kinds of things that an organization needs to be specifically thinking about as they are particularly going through a transition from one name to another. And there's a lot of interesting things to be thinking about. And I think it'll be really good for anyone who is just interested in the process or is looking at the potential of making a change or needing to, as Sharon suggested, have another trademark, whether that's for another business or another product or service that you offer. So I think, if this was a little theoretical and you're craving something even more practical, then we will definitely deliver there. And we'll be sure to put a link to that in the show notes once that happens. So Sharon, looking forward to having you on the show for that conversation.
I'm looking forward to it too.
So for now, thank you for being with us. And to all of our listeners, that wraps up another episode of The Intangible Brand. If you found value in our conversation with Sharon, please take a moment to follow or subscribe on your favorite podcast platform. We'd really love to see more subscriptions on YouTube, more subscriptions on Spotify, Apple Podcasts, wherever it is that you download podcasts. It means a lot to us. It helps us to attract the kind of guests that will make great conversations. That support that you provide in that way is super helpful to us, and we appreciate it so much.
Yeah, just to underscore the importance of YouTube, if you happen to be watching this episode on YouTube, please go ahead and like the video and then again, subscribe to our channel because it is the way that others can discover this show and join our community.
And we also love the feedback. So we'd love to hear your thoughts on today's episode. Leave a comment for us or a review or email us at hello@theintangible brand. Tell us what you liked about the episode. What do you want to hear next? If you have questions that you'd love us for us to cover.
And LinkedIn is yet another way in which you can connect with us. So LinkedIn, or you can visit our website at theintangiblebrand.com. There you'll find more information, resources, a lot of good stuff.
Awesome. Well, thank you all for joining us for another episode of the show. We are always looking to help connect you with people who will help make your brand stronger. It's all about that connection between client experience and employee experience, and how do we strengthen that? And I think today's conversation was a good example of how you can do that. So thank you all.